Welcome. I'm your host, and today we're getting straight to business. We have here is a definitive explainer of Indian family law. Now, this is going to be some dry reading of textbook rules, all right? We are looking at a fast-paced, highly structured masterclass that traces the actual arc of human life under the law. We're going to navigate the divine origins of Islamic jurisprudence, walk right into the intense constitutional battlegrounds of the Supreme Court, and finally map out the secular safety nets governing unions and legacies in India. Let's get right into it. Here is our roadmap for this explainer. We'll trace this journey step by step. First, foundations of marriage. Second, divorce and triple talaq. Third, landmark maintenance battles. Fourth, custody and guardianship. Fifth, property, waqf, and succession. And finally, number 6, secular and Christian laws.
Section 1. Foundations of marriage. Let's start at the very root of the union. Under Muslim law, marriage, or nikah, is structurally fascinating because it is not a sacrament. It's strictly a civil contract. And like any valid contract, it demands a clear proposal, simultaneous acceptance, and absolutely free consent.
But before we go further, you absolutely need to grasp this fundamental jurisprudential split. The primary sources of Muslim law, right, are the Quran and the Sunnah. But what happens when there's a gap? How do we interpret the law? Well, the majority Sunni school uses qiyas, which is analogical deduction. They basically apply principles from the Quran to new situations by analogy. But the minority Shia school, they fiercely reject qiyas. They rely instead on aql, or human reason, as a distinct source of law. Keep this divide in mind, because it dictates so much of what follows. Now, when a nikah is contracted, it's going to fall into one of these categories. A sahih, or valid marriage, naturally creates full legal rights. A batil, or void marriage, is an absolute nullity, no legal effect whatsoever. But listen to this carefully. Sunni law actually features a highly interesting third category, fasid, or irregular. If a marriage just lacks a specific formality, say it's missing witnesses, it isn't outright illegal. It can actually be regularized later. Shia law, however, does not recognize this middle ground at all.
Here's a fact that surprises a lot of people. Dower, or mahr, is absolutely not a bride price. Scratch that idea entirely. It is a fundamental, non-negotiable legal right of the wife, given as a mark of respect. Prompt dower, or muajjal, is payable immediately on demand. In fact, a wife can lawfully refuse cohabitation until it's paid. Then you have deferred dower, or muajjal, which acts as this vital financial safety net, payable only upon the dissolution of the marriage, either by death or divorce.
Moving on to Section 2, divorce and triple talaq. What happens when the union breaks down?
You see, dissolving this contract is definitely not a one-way street. Beyond the husband's traditional talaq, pay close attention to talaq ul-tafwiz. This is a formidable legal protection. This is where the husband actually delegates his power to divorce directly to the wife, right in the marriage contract. She also has the power to initiate khul by offering to return her dower, or both parties can simply look at each other and mutually agree to part ways through a process called mubarat.
However, there is one specific form of the husband's talaq that literally sparked a constitutional earthquake in India. I'm talking about talaq-e-bid'at, or instant triple talaq. The legal landscape shifted drastically here, starting with a monumental Supreme Court clash in 2017 that eventually forced Parliament to step in by 2019. Let's look at exactly what happened.
So here are the facts. Shayara Bano's husband handed her an instant triple talaq simply by writing a letter, just like that. She took this to the Supreme Court, and a 5-judge Constitution bench came down heavy, ruling that breaking a marriage permanently by a single, irrevocable utterance without any chance for reconciliation is manifestly arbitrary. They struck it down completely under Article 14's right to equality, declaring it was not an essential religious practice. This ruling was so definitive that it prompted Parliament to officially criminalize the act in 2019.
All right, Section 3. Landmark maintenance battles. This is where secular law and personal law collide head-on.
You need to commit this timeline to memory, because this right here is the absolute core of India's maintenance jurisprudence. It's a 3-act drama: a landmark judicial ruling in 1985, a swift legislative override by Parliament in 1986, and a massive harmonizing verdict from the Supreme Court in 2001. Let's start with the facts of the Shah Bano case. Absolutely vital. Shah Bano was a 62-year-old woman divorced after 43 years of marriage. Her husband paid her a paltry 179 rupees a month for the brief iddat period, and then claimed his obligations under Muslim law were completely done. So she invoked Section 125 of the Criminal Procedure Code. Now, this is a secular law designed specifically to prevent destitution, and the Supreme Court backed her up. They firmly mandated that Section 125 applies to all Indian citizens, regardless of religion. They explicitly ruled that personal law simply cannot override a secular statutory provision designed to prevent vagrancy, ordering maintenance well beyond the Iddat period.
Well, there was massive pushback. In response, Parliament passed the 1986 Act, trying to limit the husband's financial liability strictly back to the Iddah period. But the Supreme Court wasn't done. They stepped right back into the ring with the Danielle Latifi case in 2001. Using Article 21, the constitutional right to life with dignity, the court read that 1986 statute incredibly broadly. They ruled that when the law says a husband must make a reasonable and fair provision during the Iddat period, that provision must actually be substantial enough to secure the divorced wife's entire future. It has to be adequate for her lifetime, or at least until she remarries. A brilliant legal maneuver.
Let's shift focus now to Section 4, Custody and Guardianship. How the law protects the most vulnerable, the children.
Now, you have to clearly separate these two legal concepts in your mind. Hazinat refers to the day-to-day physical custody of the child, and this is predominantly vested in the mother during those crucial early years. Wilayat, on the other hand, is the strict legal guardianship over the minor's property and their marriage. And under classical law, this legal authority is always vested in the father and the paternal grandfather.
But here is the ultimate rule from the bench, a unified standard across the entire country. In the Nail-Rotten Kunnu case, we had a bitter dispute between a father and maternal grandparents. The father stood there claiming his strict legal right to custody. But the Supreme Court declared, quite forcefully, that rigid personal laws must step aside. The welfare of the minor child is the absolute paramount consideration, period. The courts are going to look at emotional bonds, education, a settled environment, and they will override the strict legal rights of any guardian across all Indian communities to protect the child.
Moving on to Section 5, Property, Waqf, and Succession. Let's talk about wealth and legacy.
Under Muslim law, a gift is called a hibah. Basically, it's an immediate transfer of property without any exchange of money during the donor's lifetime. But listen, just making a promise, not going to cut it. For a hibah to be legally ironclad, 3 precise steps must be perfectly satisfied. Ijab, which is a clear declaration by the donor. Qabul, the explicit acceptance by the dani. And this is the crucial one, qabza, the actual or constructive delivery of possession. If you don't hand over possession, the gift is simply incomplete. No exceptions.
Now, what if you want to leave property behind using a will or a wasiat? Well, you run into a strict mathematical reality. A Muslim cannot just will away their entire empire to whoever they please. The law puts a hard cap on bequests at exactly 1/3 of the estate. It fiercely protects those remaining 2/3, strictly reserving them for your legal heirs. In fact, you can't even leave that allowable 1/3 to an existing heir unless every single one of the other heirs gives their explicit consent after your death.
But beyond giving to individuals, you can choose to dedicate your property directly to God. This is known as a waqf. Governed by the Waqf Act of 1995, permanently dedicating your property means it is absolutely irrevocable. You must be an owner of sound mind, and the dedication has to be for a lawful, religious, pious, or charitable object. Once you make that dedication, the property literally belongs to the Almighty. On earth, it's managed by an appointed caretaker called a mutawali, who operates under the very strict supervision of the state waqf boards.
Finally, Section 6, Secular and Christian Laws. Let's step out of personal religious laws for a moment and look at the alternative frameworks. If a couple decides they want to marry completely outside the bounds of their personal religious laws, they use the Special Marriage Act of 1954. This is a purely civil, secular route to union, but it demands strict secular prerequisites. Neither party can have a living spouse, both must give valid consent with a sound mind, you've got to meet the minimum age, 21 for males, 18 for females, and you cannot fall within prohibited degrees of relationship. Now this is the kicker. By choosing to marry under this secular act, the couple's future inheritance is completely stripped away from their religious personal law and falls squarely under the secular Indian Succession Act. Speaking of which, for Christian families in India, the Indian Succession Act of 1925 governs what happens if someone dies without a will, meaning dying intestate. And the division of that estate is basically a rigid mathematical formula applied uniformly by the courts. If there are only lineal descendants left behind, they split the whole estate equally. If there's a surviving spouse and descendants, the spouse takes a strict 1/3, and the descendants take the remaining 2/3. It's cut and dry with absolutely no room for ambiguity. So we're going to close out this masterclass by asking a pretty heavy question. When you look at the striking down of instant triple talaq under Article 14, or the mandating of fair maintenance for a lifetime under Article 21, you see a clear pattern. The modern constitution is consistently challenging and pushing back against traditional boundaries. As these secular rights increasingly intersect with ancient scriptures, what is the ultimate future of personal law in a constitutional democracy? Will secular principles eventually rewrite the entirety of India's personal laws? I want you to really think about that. Until next time, keep analyzing, keep questioning, and keep learning.